Oh, umpisa na.
Oo. Ano lang ako na rin.
$250 na, Liam.
Actually, naka-live ka na dito.
Sige, umpisa na. This is the second series of the online pre-bar review. We have finished last time criminal law review, and now we will tackle commercial law review guided by the syllabus. I have prepared a manuscript for this study guide for the bar on mercantile law review. Since this is going to be published, I made it as comprehensive as possible for future reference of those who will take the bar after this year. But today, we will discuss the principles that are covered in the syllabus. For those of you who may miss this lecture, this will be available in 10 days because I will have it printed by the Central Book Supply, and I will cover the cost so that it can be released before the pre-week next month for the bar examination in November. And I also hope to do this also in the other remaining subjects. For next week, we will do our online review from 1 to 5 on Saturday, October 8, and we will tackle civil law. I was the examiner in civil law for the year of the bar in 2017. Civil law is also difficult in the sense that there are 5 books covered under the civil code, and there are many amendments like the family code that are covered by the examination. But bar takers nowadays, starting the pandemic, are very lucky. They have the advantage of limiting the coverage of the examination in the syllabus. So we will be guided by the syllabus. But then you are expected to turn in more quality and adequate answers because you are already given in advance the coverage of the exam, and you will have more time to concentrate in your preparation for the bar. Now, I repeat before we continue, the bar examination is a test on your adequate knowledge of the law and your reasoning ability based on logic, common sense, and the application of the principles of law involved. And the advice that I always give is answer only the questions. Do not answer what is not called for in the question. Now, an answer which starts with "it depends" is not advisable, because you have to work within the facts given or the facts that might be implied and answer only the questions. You do not have to elaborate on the principle as long as you have answered the question. And again, at the risk of being redundant, do not repeat the question. If it is answerable by yes or no, say yes because give the reason. Yes, for the following reasons. And the reason always is the applicable provisions of law applied to the relevant and material facts. I have outlined in my previous bar review the basic principles in each subject. It was very difficult before to conduct a bar review in commercial law because there are so many subjects that are covered. The old code, Spanish Code of Commerce of 1889 on maritime transportation. And you have the negotiable instruments law, banking law, Securities Regulation Act, which are not covered in the present bar examination this coming November. However, you have to correlate, integrate, and assimilate related or kindred provisions which might not be covered but might be relevant and material, and a question might be asked. I am looking at the question on rather the coverage in commercial law, and there is a listing there of uncertificated security. The definition of uncertificated security is found in the e-commerce law, which is subject to coverage in the exam in commercial law. Now, although Securities Regulation Code governing transactions of registered securities before the stock exchange is not included, an uncertificated security, a share of stock that is transmissible under the e-commerce law and may be the subject of transfer or sale in the stock exchange, as long as it is covered by recognized electronic signature. That is a valid transfer. So you have to correlate the related principles of law, because those not in the coverage that are related in the covered subject might be asked. For example, last year, or was it in 2017 when I was the examiner in civil law, a question was asked in commercial law involving bulk sales law, which is outside the coverage of the examination. Bulk sales law, the old Code of Commerce of Spanish Code of Commerce of 1889, which are valid until now on provisions or subjects that have not been amended by other laws, such as the corporation law, the civil code on and other new laws. Those are still valid until now. And you might be asked a question, involving the bulk sales law of sale of all or substantially all of the assets, merchandise, or business, or equipment or fixture. And you might be asked, in one actual examination question, the question was, all the assets were offered for sale by all the holder of the stock, common stock preferred shares. But the financier who came in as a preferred stockholder with no voting rights is objecting. And the question is very simple. In the intended sale of all or substantially all of the assets of the corporation, may the objecting preferred stockholder be allowed to vote? And of course, in corporation law, where fundamental changes in the capital structure, for example, investing in another line of business, merger, consolidation, issuance of shares of stock, and included among them is sale of all or substantially all of the assets of the corporation which fall under the bulk sales law. It is considered as, it is included in the enumeration of fundamental changes in the corporate capital structure that requires a two-thirds vote of all the subscribed outstanding capital stock of the corporation, including the preferred shareholders who are not who normally are not entitled to vote. But in case of these fundamental changes, including sale of all or substantially all of the assets of the corporation, two-thirds vote of all the subscribed and outstanding capital stock is required. And in relation to this, there is a bar question that was asked. May the objecting preferred stockholder exercise his preemptive right where the corporation would like to invest in another corporation with another line of business? It's the same answer. And I cannot overemphasize the importance of the 60-40 nationality requirements. Because in Tebes versus Gamboa, which has been reiterated in another decision of the Supreme Court, adopting the grandfather rule on foreign investment in a Philippine joint venture to engage in partially nationalized economic activities, such as transportation, 60-40, development, exploitation of natural resources, 60-40, and operation of mass media, 100% Filipino capital. And there is a constitutional provision that the Philippines, the state, encourages the formation of industries in the hands of Filipino capital. And 60-40 is allowed. So, Foreign Investment Act is not included in the list, but it falls under the coverage of corporation. And the Corporation Code has ever since a provision, even before the amendment recently introduced, has a provision on foreign corporation. Although the details and the regulations governing foreign corporations are provided in the Foreign Investment Act of 2004. So I have included a comprehensive outline of the Foreign Investment Act. What are in the negative list, where a foreign corporation may not engage 100%. But of course, there are exceptions with respect to financial and technical assistance group under the Bogal decision, because the Supreme Court, rather the law is what the Supreme Court says it is. Under the Civil Code, decisions interpreting the law are part of the law of the land. Now, I am carried away, starting with corporation law, but let us follow the syllabus. Let me start with transportation. Anyway, the coverage in transportation is very short. See, what may be insured, and then insurable interest, double insurance, over insurance, and although it is not listed here, co-insurance is involved in double insurance and over insurance. So we will take that up, and we will define what is double insurance, what is over insurance, what is co-insurance. But just remember that the insurable interest cannot exceed the value of insurable interest, because if it exceeds the value, there will be sharing, and there will be corresponding refund on the premium. Now, let us start with what might be insured. Now, what might be insured was asked in the bar in 2017 when I was the examiner in commercial law. No, not commercial law, civil law. The question is, what is insurable interest? And then a problem is given. A is the owner of a high-end sports car, very valuable. He lends it to B. So B can use it in an occasion that he wants to use it. Now, A has A insurable property on the car, the owner. Has B insurable interest on the car when he is entitled only to the use of the car. Now, that question may be answered if you know the definition of insurable interest. Now, let me read the provision. This is the way you answer. Anyway, it's very short. You memorize that. Insurable interest is interest where a person has in the subject matter which he has in connection therewith in such a way that he will derive pecuniary benefit or advantage from the preservation of the subject matter, or will suffer pecuniary loss or damage from its destruction. So, just remember, 2 keywords, memorization skill. The keyword is preservation. If he has pecuniary interest in the preservation of the property, such that he will suffer loss, benefit, or advantage in case there is loss, damage, or destruction. So, number 1, pecuniary interest. And then, number 2, pecuniary interest in the use of the property. And then, number 2, will suffer from the risk of loss, damage, or destruction. Now, answer, very simple. A, as owner, has insurable interest over the car which he owns because he has pecuniary interest in its preservation, and he will suffer loss in case the risk insured against loss or damage occurs, and that is the insurable interest of A. Now, how about B? He has a pecuniary benefit from the use of the property, and he will suffer a loss from such benefit if the car is lost or damaged. So, here is my answer. Yes, SIT and SIN have separate insurable interests. SIT has legal and equitable interest as owner, while SIT has interest in the safety of the vehicle for which he may suffer liability in case of loss or damage to the vehicle. Malayan Insurance versus First Insurance Company. That's why you bar-takers should read the cases from the original. During our time, there was a scarcity of textbooks. Our assignments were all cases to be read from the original when there were no Xerox machines in 1970. So we were forced to speed read and to learn the technique of looking at the keywords and getting the main ideas from the printed words and summarizing them in our own brief, simple notes so that we can answer all questions. A law student was complaining to me that he cannot catch up with the many decisions assigned to be read, and the recitations would be based on the decided cases. So I have made in my study guide how to digest cases. Just look for the 6 more important facts of the case. The who, that will determine the parties. What, that will determine the causes of action or the crimes committed. When, that will determine whether there is a prescription or whether the case was filed within the prescriptive period, subject to the exceptions. And then where, that determines the venue of the action. And venue in criminal cases is jurisdictional. In the same way that venue in corporate suspension of payments under the Financial Rehabilitation and Insolvency Act is jurisdictional. It is in the main office as listed in the Articles of Incorporation. However, there is an exception. Like I said, the law is what the Supreme Court says it is. According to the Supreme Court, where the address or main principal place of business indicated in the Articles of Incorporation is different from where the corporation is holding its principal business, then that is the exception. You can file a case under the intra-corporate dispute or under the financial rehabilitation and insolvency law in the place where the corporation is actually holding business. That's why even lawyers, practitioners should be abreast of the developments of the law and jurisprudence, because any misstep would be fatal. I have many examples where I won by technicality on big cases. Oh, let me just give an example. In commercial law, a client of mine had a loan, and the bank sold the commercial papers to a special purpose vehicle corporation for a very low price. The computation, including interest and penalties, would amount to 103 million pesos, because it has been so long that the account was overdue, and since this is an old account, it was sold at only 3 million, among many others, by the bank. Now, under Article 1634, where an item in litigation, a chose in action is sold, there is an equity of redemption by paying only the purchase price. So, when the client attended my seminar, he came to my office, and I just advised him, you consign 3 million to the RTC of Makati, where the case is pending. I collection against him for the full 103 million. And we did that. I banking the bank together with the Special Purpose Vehicle Corporation went directly to the Supreme Court to review the decision on pure question of law involving our exercise of the equity of redemption by consigning the transfer price. Now, in commercial law, although this is not subject to the coverage, an interest is due when there is demand. Without default, there is no interest is due. So, we were affirmed by the RTC, and immediately the opposing counsel went up to the Supreme Court on pure question of law under Rule 45. I did not even bother to file a comment or opposition. I was not even required to file a comment or opposition by the High Court, because there is a violation of the hierarchy of court. And although this is relevant in remedial law, you cannot be a specialist in the practice of law. You have to integrate and correlate, because your defense might be found in another branch of the law. So, the Supreme Court dismissed the petition for violation of the doctrine of hierarchy of courts. The aggrieved party should have gone first to the Intermediate Appellate Court, the Court of Appeals, because going directly to the Supreme Court, except if the issue involves high and mighty constitutional question that involves transcendental importance to the nation, you cannot go directly to the Supreme Court. Although under Section 1 of Article 8, you can always go to the Supreme Court if you can show grave abuse of discretion. But then the principle of transcendental importance involving public interest, transcendental importance to the nation, must be must be hurdled. And that's why the Supreme Court before was very liberal as long as there is involvement of disbursements of public funds. A citizen, any Tom, Dick, and Harry who is a taxpayer, a Filipino citizen, may go to the Supreme Court. But now, a direct interest is required. But I will go into that because that is outside the topic of my coverage. So let us go back to insurance. A question was asked involving all risks insurance. And this is not taught in the law school. But then, if you read the decision, there is a decision within the coverage when this was given up in the 2017 bar examination. And the question calls for the application of what are the defenses available to an insurance, to an insurer, such as concealment, misrepresentation, non-payment of premium, and this also involves the contestability clause that the insurer may raise the issue of concealment, misrepresentation, or suicide. Incidentally, suicide was asked in the last bar. But the answer is very easily answerable if you know the rule. For example, on suicide. Whether within the contestable period of 2 years or not, if the suicide is due to insanity, that is compensable. Now, outside the contestability period of 2 years from the issuance or renewal of the policy, suicide is not a defense anymore to the insurer because it is barred by the incontestable clause. So here, it is listed here, no fault, suicide, and incontestability clauses. Now, I think that no fault might be asked here. And I have indicated I have outlined the requisites for a no fault. Regardless of the fault or negligence of the insured in third-party liability insurance, where a passerby or anybody has an accident, whether it is caused by his negligence or not, under the third-party insurance liability, he can recover what is stipulated in the third-party liability insurance, whether to passenger or to third party. And the requisites are very simple. There must be a claim, and there must be a police report, and there must be a medical certificate. That's all. And that is immediately recoverable. From what I understand, there is an obligatory or mandatory 5,000 no-fault insurance. But the amount, if it is provided as a clause in the policy, no-fault insurance liability, the amount would be dependent on what is fixed in the policy. But if I am not mistaken, there is a mandatory 5,000 immediately payable, as long as the requisites, and I repeat, a claim, police report, and medical certificate is all that is needed to claim the no-fault insurance. So I do not believe that there will be a question on suicide and incontestability clauses, although there is listed what are the defenses available to the insurer. And one of them is lack of insurable interest. That's a defense which would require reimbursement of the premium. The most important provision in insurance, to my mind, is Section 77 on the synagmatic characteristic of insurance. What do you mean by synagmatic characteristic of insurance? Insurance is a risk distributing device, and it survives from the pool of the premiums put together. And if the time comes that insufficient premiums are collected, then the insurance business may fold up for lack of capacity to pay maturing policies. A question was asked in the bar, when is an insurance policy perfected? Again, you have to correlate this with civil law. What are the elements of a valid contract? Meeting of the minds on the subject, which must be an object certain, and on the consideration. The meeting of the mind on the consideration must be exact, because in one case where a lot was purchased from Ayala Land, there is a meeting of the mind on the amount and on the subject matter. The lot is specified, but the agreement on the payment of the purchase price is by installment, to be subject to negotiations. According to the Supreme Court in Ayala Land versus Manalo, which to my mind is a leading case in sales, there is no valid contract of sale because there is no meeting of the minds on the cost or consideration. Now, let us consider a case that I am handling now. A sale of a farmland in Silang, Cavite. 3 documents were prepared by the buyer, assisted by the lawyers of his law firm. One is a contract to sell for 17.5 million. Another is a deed of sale on exactly the same property for 7.5 million, indicating that the purchase price has been fully paid when no payment is made. And a down payment in the mind of the buyer was paid to her, but documented as a loan agreement with real estate mortgage to be used in the transfer of or registration of the title in favor of the buyer. Question, is there a meeting of the minds? No, because the two documents are inconsistent with each other. One states 17.5, the other states 7.5. And what is even worse, in a contract to sell, there is normally a down payment, but the down payment was extended by way of a loan with interest, interest bearing, and the proceeds to be used in transferring the title in the name of the buyer. The transaction was negotiated by the brokers, and one of them is even a son-in-law of the buyer. And the brokers collected 5% on the entire 17.5 as advance commission. And then the other portion of the 2.5 after the commission were used in transferring the property. All the documents were prepared by the buyer and the lawyer. The seller is an old lady based in the U.S. who came here selling the property because she is in dire need of money for the medical treatment of a brother. Now, my question is there a perfected contract of sale? I have already sent a notarial demand for rescission with an offer to pay back or refund the down payment of 2.5 million. And in the subsequent events, the buyer is demanding payment of interest, 5%, or rather 5% per annum, 0.5% per annum, and 1% penalty. So since the sale has not been consummated, interest and penalties probably would amount to about 2.5, double the amount. But anyway, that is an actual case, but I discuss it hypothetically in the name of academic freedom, just to dramatize the requisites of a valid contract. If there is no agreement, which must be exact and precise and definite on the cost or consideration, where the installment payment is still to be negotiated, or where there is a dispute whether the 2.5 is a down payment or a loan, but it is documented as a loan. And but then I will not go into further details. This is only a hypothetical question on whether or not or when the contract of insurance is perfected. We apply the law of contract. And in the application of the law of contract, there is a principle that one contracting party cannot dictate all the terms, because one of the essential characteristics of a valid contract is mutuality. That is, in the negotiation, the old lady was not represented by a lawyer. All the documents were presented, prepared and even notarized in the law office of the buyer. And so what has happened now, the property is already in the name of the buyer without paying for the purchase price, except the 2.5, which is standing on the fence, whether it is a loan or whether it is a down payment. Even treated as a loan, because the simultaneous document treats it as a loan, no interest is due, because the rule in the civil code is without default, or rather without demand for payment, there is no default. Without default, no interest is due. And how can you impose interest on the down payment when the contract to sell does not impose interest on the balance? It is subject to several stringent conditions which are beyond the understanding of a layman. But anyway, that is the law on the perfection of the insurance policy. Now, Section 77 provides that notwithstanding any agreement to the contrary, no policy of insurance shall take effect except upon payment of premiums, subject to the exception that where a grace period is given in case of health, life, or accident group insurance. So that is one exception, that is grace period provided by Section 77 itself. Before Congressman Nani Perez of Batangas introduced the limiting phrase, subject to any agreement to the contrary, there were jurisprudence that where there is extension of credit, then extension of credit is an exception that the insurance policy will take effect even if the premium is not paid, if there is credit extension. But the law precisely abandons and outlaws credit extension. Then came UCPB versus Masagana Telemart. This is what happened in this case. The insured is holder of fire insurance policy. In the past, the insurer allows the payment of the policy for the preceding year even after the expiration of the policy. The policy has expired, the premium has not been paid, the building insured against is gutted by fire. The insurer, or the insured, paid the insurance premium for the last lapsed insurance policy and made a claim. The case came up to the Supreme Court, and in the initial decision, of the Supreme Court, I think it was Justice De Leon, who introduced the concept of synagmatic characteristic of insurance. That payment of insurance is indispensable, except in the case of group life insurance where a grace period is allowed, and also except as provided in Section 78, that if payment of premium is acknowledged in the policy itself, then the insurance policy is effective, and it is up for the insurer to collect the policy. So, in that case of UCPB versus Masagana Telemart, the division in the Supreme Court unanimously held that the insured cannot collect. On motion for reconsideration, Chief Justice Davide as ponente reversed the initial decision and held that the insurer is liable on the following grounds. Number one, the insurer in the past has the policy of allowing payment for lapsed insurance policy. And number two, the insurer is under estoppel. And then I'm questioning, why under estoppel when the insured conceals the fact that there is nothing more to insure? The building is already gutted by fire. And is that not fraud? And what was not discussed is the amendment introduced by Congressman Nani Perez that notwithstanding any agreement to the contrary, no insurance policy shall take effect except upon payment of premium. That was not discussed in the motion for reconsideration. So now we have exceptions to the effectivity of the insurance only upon payment of premium. One is as provided in Section 77, in case a grace period is provided for group, health or life or industrial insurance. And then under Section 2, where there is an acknowledgement in the policy itself and that the premium has been paid, although it has not been so paid. And number 3, where the insured is insurer is under estoppel. And I may add, if there is an admission or acknowledgement in the payment of premium in a genuine document. So those are the exceptions. Now, a question was asked. And this was already in my outline in 2005. That is the effect of payment of insurance premium by post-dated checks. So here is the problem. Insurance policy is taken out. It was issued upon payment of a post-dated check. Before the maturity of the check arrives and the check is encashed, the building covered by the insurance policy is gutted by fire. The check bounced for insufficiency of funds. what the insured did is to make good the deposit and advise the insurance company to redeposit. And the insurance company complied and redeposited the check, which eventually cleared question. May the insured recover? The answer is yes. Based on the Masagana Telemart, the check was accepted, the redeposit was honored, and so anyway, the premiums eventually was paid. In my review notes in commercial law, I had a different answer, and I was questioning the decision, the Davide decision in the UCPB versus Masagana Telemart, because the law is clear. There is no need for interpretation. Notwithstanding to the agreement to the contrary. And so a credit extension is an agreement to the contrary on the payment of premium. And it is not provided by law. And this was my answer. Under the Civil Code, a check takes effect as a valid payment upon encashment. However, accepting a check is a valid form of payment subject to the resolutory condition that the payment will be set aside if the check is dishonored. So that is what I said. Now, in the meantime, that the maturity of the check has not arrived, the creditor or the obligee cannot sue or cannot compel the issuer of the check to pay, because payment of postdated check is subject only to the resolutory condition if it bounces. But then, on balance, if you are asked this question, you just follow the decision of the Supreme Court. Like I said, the law is what the Supreme Court says it is. So we should follow the decisions of the Supreme Court, but we are not precluded from criticizing constructively the decisions of the Supreme Court based on logic and common sense. Now let us continue with the coverage of insurance. All right. I think we better go to commercial law. Corporation law, rather. Then transportation. Now, double insurance, over-insurance, co-insurance. there is double insurance if there is an insurance by the same insured to the same insurer to the same property under the same insurable interest. That is double insurance. Now, there is over-insurance if the insurance exceeds the insurable interest. Now, this double insurance, over-insurance, under-insurance would be applicable only to property insurance because life insurance is always a valued policy and there is no limit to the amount of the insurable interest. Now, as long as the one taking the insurance has a pecuniary benefit from the preservation of the life of the insured. For example, those who are entitled to support each other and going back to the family code or the civil code on persons and family relations, the grandchildren have insurable interest in the life of the grandfather who may be liable to support the grandchildren if the parents cannot support them. So there should be a pecuniary interest and the interest is in the preservation of the pecuniary interest in the subject matter. Now, let us proceed with insurance. Oh. Now, there is over-insurance if the amount insured exceeds the insurable interest. Now, there is co-insurance where the property is underinsured, meaning that the value is more than the insurance taken, and there is a formula under the insurance code on that, and that is the value of the loss, or rather the risk of loss over the value over the insurable interest, and that will be the liability of the insurer. Now, let me see. I have written something on that. Here. Sorry. double insurance, read section 95. That is insurance by the same insured against the or with the same insurer on the same insurable interest under section 95. Now, over insurance is where the coverage exceeds the insurable interest. Now, there is co-insurance where the insurable interest or the value exceeds the insurance taken, and the liability of the insured is computed by dividing the loss by the value of the property and multiplying it with the insured's liability. And that is the formula for co-insurance. That is in the case of under insurance. Now, this is briefly explained on page 36 of this study guide, which will be printed in 10 days from today. Right, let us go to transportation. The most important concept in transportation is the definition of a common carrier. Now, a common carrier tranships passengers and goods by land, air, or sea. The two most important requisites is for compensation and offered to the public. Just remember those two. Now, if it is not offered publicly, it is a private carrier, and there is no presumption of negligence. And the defense of extraordinary diligence is not required for a common, for a private carrier. A common carrier is presumed to be negligent in any event of death or loss of cargo or goods. So it is very important to know what is a common carrier. We were joking that a common carrier is like a prostitute. It is open to the public and it is for profit. If it is not for profit, if it is not compensated, that is not prostitution. Even if it is for profit, if it is not open to the public, then it is not prostitution. So, pardon me, but in our naughty days, just to be able to remember the element, we use this naughty analogy of a prostitute and a common carrier. So in the bar, a question was asked. A newspaper vendor, then the wife of the driver, and a stowaway. boarded the bus, which met an accident. And the question is, number one, can the stowaway claim indemnity? The answer is no, because he did not pay. He did not pay. How about the wife of the driver? There is a contract of carriage because she was allowed by the driver. It is fringe benefit of the driver, so there is a contract of carriage. The newspaper vendor, there is no compensation for transporting him, so he is not compensable for the accident. Remember that an insurance policy is a contract of indemnity only for property insurance. Life insurance policy is always a valued policy. So the insurable interest is any amount that can be covered by the premium of the one taking out the insurance policy on the life of the insured. In the bar, sometimes you are surprised by a question you did not encounter before. When I was the examiner in 2017, there was a question on what is the nil doctrine. I do not understand what is the nil doctrine. It is based on a case, but the examiner is very fair because he describes in the question what is the nil doctrine. And of course, the bar takers are familiar when the ruling applying a particular provision of law is described, but then in criminal law, in 2017 bar, there was a concept or doctrine based on a decided case that was not described, and a question was asked on that, or an explanation is required. To me, that is unfair. And in 2017, I believe that less than 20%, 18 or 16 only passed in criminal law. But in civil law, 11 bar takers got a perfect score, 100%. And in my subject in civil law, 60% was the passing average. The same passing average with the other examiners, like Justice Lopez, who is now in the Supreme Court, who also made a passing average of I think 59 or 60, same as mine. And so during the induction, the more liberal examiners got the loudest applause because we were able to bring up the general passing average in that 2017 bar examination. I took a leave of absence. I went to the United States to hide my appointment as examiner in civil law. I did not teach any subject, and I did not even conduct bar review lecture in the University of Manila, where I am the dean and bar review director. And also, I did not even give a hint to the UP Law Center, to the Ateneo bar review, where I used to handle review classes, or in any other schools. But my materials for the previous bar were distributed free to all who may be interested. And so, where else will I get my questions except from my books? And so those who read my book did not have much problem, because I have an instruction on how to answer bar questions. And I have mock bar exercises on what I predict might be asked based on the syllabus. And what is very important is pay particular to the updates where previous doctrines are abandoned and reversed by the Supreme Court, or conflicting decisions are harmonized by the Supreme Court. Because you see, there are always two sides to an issue, and there are exceptions. One decision may be decided based on the general law, the other based on the exception, and still another one may be decided based on the exception to the exception. So that is the beauty of the law. You can use your creative imagination to formulate theories. Now, speaking of unfair question, the butt of jokes by reviewers in commercial law, and I'm telling you, there are very few of us before who are specializing in commercial law, because there are so many subjects. It's very difficult to be a reviewer on commercial law. Can you imagine the coverage? But then, here is the butt of joke. What is a supercargo? Now, although maritime transportation is excluded, there are concepts that that might be the subject if related to the coverage. Now, supercargo is a concept in maritime transportation. Now, before, there was a question, what are the duties of the captain? But then, crazy question like this is not being asked anymore. Now, if you are asked what is a supercargo for 1%, it is not a big cargo. A supercargo is a person. He is a troubleshooter in the ship. So he is a person employed by the owner of the ship to take care of any problems in the ship. In other words, he is a troubleshooter, fixing problems in the ship. So a supercargo is not a cargo. He is a person. the boy Friday of the ship, troubleshooter of the ship. Now, on the liability of a common carrier, who is a common carrier and who is a private carrier? So, those are the two requisites. Open to the public and for compensation. Now, how about a custom broker? According to the decision of the Supreme Court, a custom broker is a common carrier liable for the safety of the cargo that is transshipped from the vessel, unloaded, and transshipped by the custom broker to the bodega of the importer. So, he is liable as a common carrier with presumption of negligence. And the only defense is fortuitous event. Now, due diligence in the supervision and selection of employees, due diligence of a good father of the family is available as a defense to a common carrier. Now, a question might be asked, when is a ship carrying goods inter-island is a common carrier or not? It depends on the kind of charter party. Now, if a question is asked, what is a charter party? What are the two kinds of charter party? If you do not know the definition, you might guess. As one who did not study enough would answer, a charter party is a party organized and held in the ship. That is a charter party. That is not correct, because a charter party is a lease of the vessel. So, if it is a voyage charter, meaning that the what is leased is only the ship or the vessel, and the complements, the personnel, are not covered by the lease, that is called a voyage charter. And the charterer is liable only as a private carrier, and the owner is still liable as a common carrier. Now, as contradistinguished to a bareboat or damaged charter, which is a charter on the entire vessel, including the crew and the personnel. In that case, during that particular voyage, the lessee, the charterer, is considered as a common carrier and is liable as a common carrier. And how about the owner, the lessor? The lessor pro hac vice, meaning only specifically during the voyage under lease, under the charter party, would be converted into a private carrier, and his liability is not that of a common carrier. It is the charteree, it is the lessee in a bareboat or damaged charter who is converted into a common carrier, because he leases and is responsible not only for the vessel, but likewise also for the crew and the complement of the ship. Now, the coverage includes Warsaw Convention. Now, the Warsaw Convention covers international travel and specifically, more specifically, limiting the risk of loss for lost baggages. It's $500 per baggage, and unless a higher amount is stipulated and the corresponding premium is paid. Now, I will not discuss anymore the provisions of the 1889 Spanish Code of Commerce on inter-island maritime navigation, because that is excluded in the coverage. But on the defenses that might be raised by the insured or by the insurer, there is a very leading decision, and I am referring to the Aboitiz decision. Among the defenses available to the insurer is under the incontestable clause, the insurer cannot raise the defense of concealment and representation. So, in favor of the insured is the incontestable clause that concealment, misrepresentation, is not a bar to indemnification after the lapse of the incontestable period of 2 years. Now, related to the defense of the insurer, where there is no payment of premium, the contract is not perfected, and I have indicated all the other defenses available because it is listed in the syllabus. What might be asked is, although this is not under the maritime navigation is excluded under the old Code of Commerce of 1889, this might be related to the defenses available to the carrier. Now, a common carrier, if it is a common carrier, is presumed to be negligent, except in case of fortuitous event or non-payment of premium. However, a common carrier in maritime navigation, inter-island, or I suppose even inter-ocean or international transshipment by plane under the Wagner, under the Warsaw Convention. Oh, I'm sorry. This is limited only to inter-island, inter-island navigation, or maybe under the Carriage of Goods by Sea Act, by transshipment through the ship or vessel. And this is the real and hypothecary nature of maritime insurance. that where the vessel sinks into the bottom of the ocean, the owner of the ship is freed from liability from the damages caused to the passenger and the cargoes. The liability of a ship owner is limited only to his interest in the cargo, rather in the ship. And if the ship sinks into the bottom of the ocean and has become a total loss, then there is no further liability incurred by the ship owner. Now, how about the negligence of the captain of the ship? The ruling before is there is no further liability. Then, in the aftermath of the 2015 accident of a ship, the Supreme Court, based on related provisions of law, abandoned the absolute ruling that a ship owner is not liable, or the extent of liability is limited only to the value of the ship. And if there is an insurance coverage, then the liability will be transferred to the insurer to compensate for the damages for the passengers who died or are injured, or the cargoes who are physically injured or who died. How about claims in excess of the coverage of the insurance on the vessel? The ruling before is under the real and hypothetical nature of maritime navigation. There is no more liability after exhausting the proceeds of the insurance, because the liability is limited only to his interest in the vessel. However, in the case of Aboitiz, the Supreme Court modified the real and the ruling or definition of the real and hypothetical nature of maritime navigation by ruling that the owner of the vessel is liable beyond the value of the vessel for the negligence of the captain of the vessel, or where there is negligence on the part of the vessel. And the negligence of the captain of the ship is the negligence of the ship owner under the principle of respondeat superior. There was a question in civil law, but we will tackle this. A boy, 12 years old, shot a classmate dead in the school. The father disclaims liability because he was not the one who shot the pupil. And the question is, is his defense sustainable? You see, the questions in the bar nowadays are very simple. So you just answer the question and give the reasons. You know, sometimes a one sentence can dispose of the answer. So you have to and I'm correlating the real and hypothetical nature because it is really a very significant decision in transportation. the real and hypothecary nature of maritime navigation. But if that is asked, then you know what that is. All right, let us go to commercial law. The coverage only insurance, transportation, corporation law, intellectual property, anti-money laundering, e-commerce law, and financial rehabilitation and insolvency act. It does not include for this year's bar examination banking laws, securities regulation code. Although there are interrelated provisions in the corporation code and the negotiable instruments law is not included, but we will make a reference on forgery with respect to the negotiations by a corporation in relation to the trust fund doctrine and the duty of obedience. The first duty of a corporate director or officer is the duty of obedience, and that is to exercise only the powers and functions granted, vested by law, expressly or by necessary implication, impliedly granted. So that any action of a corporate director outside the principal purpose of the corporation, that is an ultra vires act. And an ultra vires act does not bind the corporation because it is unauthorized. And let us correlate that to the law on agency in the Book 5 of the Civil Code. A director who committed an ultra vires act is comparable and has the same liability as an agent who exceeded the authority of his principal. And what is the result? In the Civil Code, the agent shall be personally liable, and his act, which is not authorized, is not binding on the principal. The same principle with respect to the ultra vires acts committed by a director or officer, meaning he acted outside the scope of the powers and functions vested in the corporation. Now, the duty of obedience, as a rule, has an exception. Although the acts are ultra vires, acceptance of benefits by the corporation binds the corporation to the ultra vires act. Not all ultra vires acts are illegal, but all illegal acts are ultra vires outside the function of the corporation. Now, I saw in the list of in the syllabus, best judgment rule, that might be us. And this is the principle. As long as the directors or officers has acted in good faith without negligence, he is not liable for corporate action, although the acts may lead the company to disaster, although the acts might be disastrous. So, best judgment rule, there should be good faith and there should be no negligence. And why? Because the corporation has a separate and distinct personality from the stockholders, directors and officers. Now, a question might be asked, what are the instances which fall as exceptions to the liability when are directors and officers personally liable for acts committed on behalf of the corporation? One example is where there is a JSS. The stockholder, director, or officer signed as a solidary co-obligor in the promissory note involving the loans granted by a bank in favor of the corporation. So, second requisite, where there is negligence. Second exception. Third exception, when the director exceeds the limit of his authority, meaning he violated the fiduciary duty of a director of obedience to the principal purpose, authority, and functions as found in the purpose clause, Article 2 of the Articles of Incorporation. Now, third exception, when a crime is committed by the corporation. A common example of this is failure to remit to the social security system the corresponding contribution collected from the employees. A corporation as an artificial being cannot commit a crime. So, any crime committed by the corporation shall be the personal liability of those who are acting criminally for the corporation. Under the doctrine of separation of juridical personality, where the corporation is guilty of violation of BP number 22, notice to the corporation is not sufficient notice to the officer who issued the check, because of the doctrine of separate juridical personality, that the corporation or the officer and the officer have separate juridical personality from each other. So the case will not prosper if no personal written notice is sent to the officer, because he has a separate juridical personality. Now, in a decided case, a very controversial case, there was a foreclosure of the property of a company. The one stockholder bought all the shares of the foreclosed company, and he is now contesting the rate of execution on the ground that the corporation can no longer be the subject of writ of execution or writ of possession, because he has acquired all the stockholdings of the company and he is now the owner. He is now the sole owner. The Supreme Court reiterating many decisions on the separate juridical personality of the stockholder allowed the writ of possession following extrajudicial foreclosure because the company, the respondent corporation, has a personality separate and distinct from the stockholder, and it does not matter that a particular stockholder has already acquired 100% of the shares of stock of the mortgagor company. So that is an illustration of separate juridical personality. Now, maybe it's not included because it is not listed here, but the duty of loyalty with the corresponding doctrine of corporate opportunity, that a director or officer may not appropriate for himself, may not seize for himself any business opportunity that belongs to the corporation. And the express provision of the corporation code is that he is liable to turn over all the proceeds and the appropriated or seized business to the corporation because that involves conflict of interest. Now, another very important doctrines or principles in corporation law is piercing the veil of corporate entity. Now, a corporation is an artificial being with the right to own property and with the powers to exercise the powers granted or implied by law. It has a personality, a juridical personality by fiction of law, separate and distinct from the directors, officers, or stockholders. But there is an exception where, number one, the corporation is controlled by the stockholder, and the purpose is to defeat public convenience, justify wrong, or protect fraud, or defend against crime, or warrant the commission of a crime. So these are the three grounds for piercing the veil of corporate entity. I have been teaching corporation law in UP, in the Bar Review, in the Law Center, in the regular fourth-year review in Ateneo, where I taught for almost 20 years, and in the various downtown law schools. And I have challenged my students, both in the regular course, in the review course, and in the bar review. If they can provide me with an illustration of a case of piercing the veil of corporate entity, because the purpose of the corporate fiction is to defeat public convenience. And I offer a bonus of 10,000 pesos to anybody who can give me an illustration. Until now, nobody has claimed the prize because that was these three grounds were enumerated in a U.S. case, but the case does not illustrate the function to defeat public convenience. But anyway, my offer is still stands. I'll give 10,000 pesos to anybody who can submit to me an illustration of piercing the veil on the ground that the corporate fiction is intended to defeat public convenience. So maybe it was in a transportation because it was a beer company that was involved manufacturing beer in the United States, and it's being transported, and an issue is, if I recall it correctly, is the payment of taxes. The payment and the transshipper is considered as under the control of the manufacturer. But then, where is the purpose to defeat public convenience? It is something that was mentioned in that decision, but there is no illustration so far. I studied in the U.S. and I made a research. I did not find any illustration to defeat public convenience. Now, alter ego, so it is based on the control. To warrant to defend crime, etc. That's very easy. Just look at the facts. And if the stockholder dictates all the actions, and the purpose is to insulate himself from the commission of a crime, then that is subject to piercing the veil. Then the alter ego doctrine, where almost 100% or the majority of the stockholdings are held by a stockholder who is dictating the management of the corporation. That's very easy to determine. So, as long as the corporate fiction will justify protect fraud, crime, then the corporate fiction should not be should be pierced, and the stockholder would be held liable, disregarding the juridical personality between the controlling stockholder, director or officer, and the corporation. Now, this is very important. The next one on control. The test of the nationality of the corporation. So you have domestic, if it is organized domestically. It is a foreign corporation if organized abroad. There is an exception in the Foreign Investment Act of 2004. Although the Foreign Investment Act is not specifically included, there is a section on foreign corporations in the revised corporation code. And so the nationality, the requirements of nationality, the negative list, meaning the nationalized activities, where the investments of foreigners are limited, are all governed by the Foreign Investment Act. You will see the answer when I took the bar in 1970, a question was asked, may a corporation be organized with the stockholders who are all foreigners? As long as they will not engage in partially nationalized activities, that can be done. And there is even an exception under the retail trade nationalization law that if the specified capital 2,500,000 is invested, then a foreigner may engage in the restaurant retail business. Now, what I am saying is that we should integrate the Foreign Investment Act, and I summarized the Foreign Investment Act in my handouts. This will be available to you in 10 days. And also, for next meeting on Saturday, we will tackle civil law. And then, the other remaining subjects before the start of the bar in November. The decision of the Supreme Court in Tebes versus Gamboa is precedent setting. Whereas before, the 60-40 requirements in partially nationalized economic activities, such as transportation, mining, or exploitation, development, and utilization of natural resources. 60% of the capital, meaning the voting shares, must be in the hands of Filipino citizens. What the anomaly before, the Supreme Court clarified in the precedent-setting case of Tebes versus Gamboa. The computation before was only on the common shares. And so that was, I believe that was in the initial decision. I am familiar with this because I was consulted. And I was consulted in the preparation of the motion for reconsideration. Now, the final ruling of the Supreme Court on the resolution in the resolution on the motion for reconsideration, which is confirmed by subsequent decision, adopting the definitions of the Securities and Exchange Commission of the 60-40 and the grandfather rule. This is the ruling now, and this has been asked several times, almost every year, since it was rendered by the Supreme Court. If it is not in commercial law, it is in political law. The question in commercial law is this, actual examination question, applying the Tebes versus Gamboa and the subsequent confirmatory decision, adopting the rules on the question issued by the Securities and Exchange Commission. The 60-40 requirements must be computed not only on the common shares that are voting. The 60-40 must also be computed separately on the preferred non-voting shares. Whereas before, sky is the limit on the non-voting shares. Now, a foreign investment on partially nationalized economic activities, where 60% must be owned by Filipino nationals, only 40%, even on the preferred shares, may be accommodated for foreigners. And so that brings us to control. %60 is more than majority, more than 51. And the idea is to keep the control in the management of the corporation in the hands of Filipino citizens, Filipino capital. So, in the election of directors, the 60% of the directors to be elected should be voted for by Filipino stockholders. And the foreign investor is limited only to the investment in the common shares voting. So that in the voting, the Filipino directors would prevail. However, there are provisions that may be inserted in the stockholders' agreement that may be incorporated in the articles of incorporation, where, for example, a high voting authority, which means that a resolution would not be carried without the participation of the foreigner, is a protection by way of a veto power by the foreign directors, because the foreign stockholders may elect only up to 40% of the directors. Now, that might high voting power as a veto power by the minority may have controversial and questionable validity. But anyway, that is being practiced. Which brings us to the grandfather rule. The 60-40, where 60-40 is required, under the grandfather rule, where it is applicable, the composition of the stockholder of a company with foreign investors or stockholders, which has an equity in a 60-40 corporation, where the grandfather rule will have to be applied, then the composition of the investor corporation will be taken into account to determine whether the 60% stock ownership of the Filipinos remain intact or are maintained. So that is the grandfather rule. It involves a joint venture Filipino foreign corporation investing in another corporation which is required to maintain 60% Filipino ownership. Under the Foreign Investment Act. A corporation whose capital stock is held 60% by Filipinos and 40% by foreigners is considered a Philippine national entitled to engage in partially nationalized economic activities like buying land. A company with 40% foreign interest may engage in real estate business. Now, where the grandfather rule is not applicable, as long as there is no doubt on the control of this company, as long as the investor, joint venture company, is a stockholder of this corporation, is a 60-40 and does not is a 60-40 corporation or has foreign elements, and as long as 60% is kept by Filipinos, then there is no room for the application of the grandfather rule. The grandfather rule would be applicable only if the control in the management of the corporation, where there is a 60-40 or other corporation is a stockholder with foreign investor, it is only in case of doubt. Doubt on what? Doubt on the control of the Filipino capital. Now, if, for example, the operation is being dictated by the foreigner, then the grandfather rule will be applied. And therefore, the composition of the investing corporation will be taken into account. That is the grandfather rule. Only in case of doubt, where there are facts and circumstances demonstrating that the operating joint venture corporation, although appearing as 60-40, is under the control of the 40% foreign investors. ABS-CBN. The constitutional provisions are always part of the examination in any subject, in commercial law, or in under corporation law. A private corporation cannot be organized except under the corporation code, as distinguished from public corporation. Corporations which are engaged in the performance of strictly governmental function, or private or public corporation engaging in proprietary business activities like a bank. So you have the Development Bank of the Philippines, Social Security System, and other public corporations. A public corporation might be organized to engage in proprietary function only if it satisfies two important standards. One is public interest, and number two is economic viability. So, a public corporation must be created by special law or special charter, subject to these requirements, because in the past, never mind in the past. I will not say in the past, because it may be a source of graft and corruption if public corporations may be organized without the standard of economic viability. So, all right, maybe under, a question was asked in 1970 when I took the bar. What is a sole corporation? At that time, under the old corporation code, a sole corporation is allowed only for the Roman Catholic Church. Now, with the amendments to the corporation code, before our idol President Duterte stepped down, he was able to cause the amendment allowing a single stockholder to organize a corporation with the same separate juridical personality. I just do not know if the implementing regulations has been issued. I have not heard of a single stockholder having organized a separate juridical corporation. Now, in case of death of the single stockholder, then the stockholding is inherited by his heirs. Another significant innovation in that law amending the corporation code towards the later part of the Duterte administration is with respect to the extension of a corporation whose period of life effectivity has expired. This has caused considerable problems, because the rule before the amendment is that where the corporate life has expired, it can no longer be extended, because you cannot extend what has already expired. And so what is the consequence? It is very expensive, because you have to liquidate, and then you have to pay the BIR. If you want to incorporate, you have to transfer the asset and pay taxes on the transfer. Under the new amendment, even if the corporate life has already expired, all that the stockholders will have to do to extend or renew the corporate life is to file an amendments to the articles of incorporation extending the life, even if it has already expired. And that is very important, because a corporation when its life has already, the period of its life has already expired, will lose personality. Although under the provisions on liquidation, there is a provision that the dissolved corporation may wind up its affairs, but only for purposes of liquidation, and where the stockholders neglected to hold a stockholders meeting extending the corporation life before its expiration, then it will be in trouble without these new amendments. But the amendment during the Duterte administration saved the day for them. They don't have to pay taxes because the corporate life might be renewed or extended. And what is the procedure? The directors will pass a resolution recommending to the stockholders the extension, and then the stockholders, by a vote of 2/3 of all the subscribed and outstanding capital stock, may approve the extension. And that's all that is needed. You don't have to pay the taxes. There will be no transfer of assets involved. So for the detractor of President Duterte, he has done good on our legal system, and we will discuss this when we go to remedial law. That is defining the jurisdiction, expanding it for first level court. And as you know, jurisdiction is defined by law, and since it is a matter of procedure, it has a retroactive effect all over the land. Those cases on involving real property or real action where the assessed value does not exceed 400,000 and the case is pending in the RTC, it is remanded automatically by force of law. And any judge who will violate that might be liable administratively for defiance of a mandatory provisions of law, because as you will see when we come next week to civil law, Article 5, acts done in contravention of prohibitory and mandatory provisions of law are null and void, except when the law itself provides for their validity. And the cut-off for money claims and claims for damages has been increased to 2 million pesos. And since it is a matter of jurisdiction, jurisdiction may be raised at any stage of the proceedings, even for the first time on appeal. Then, subject to the rule in the Tiham versus Sibong Hanoi on estoppel, that where there is no jurisdiction but a party prayed for affirmative reliefs, that might be considered as a waiver of jurisdiction and estoppel. Not to never mind. I'm just carried away. We should discuss this in remedial law. So can we go now to now plunder, I suppose, is not included. Is plunder included? No. Now, let us just limit ourselves to the coverage in the syllabus. So, we are now on AMLA, Anti-Money Laundering Act. Remember the three institutions, covered institutions, who must report violations of the law, who must report those that are found suspicious or in violation of the law. Ngayon, by practice, banks, if you sell a property and you are depositing the proceeds, the bank will ask you for the lawful source of your money. Otherwise, without documents showing the lawful source of your money, they will not accept the money if it exceeds 500,000. Now, in the U.S., the cutoff is 10,000 US dollars. And so, Filipinos who want to deposit there so that there will be no problem with the AMLA would deposit in current accounts where there is no interest. And they will just deposit $9,999, not 10,000, and so it stays there. And anyway, if it is non-moving, the bank is charging deducting charges for lack of movement. So it's possible that all over the U.S., if a big account is intended to be hidden, it will be deposited in several banks. And if that is done here in small banks in faraway places, that is a violation of the Anti-Money Laundering Act. Now, insurance companies and then those who are transacting business in the stock exchange, they are covered institution who must report suspicious economic transaction. Now, a question was asked in the bar. Left a handbag with 5 million pesos in the airport, which was found by B. Now, B deposited, B first transacted it by pawning it for 2 million, and it was accepted as collateral for let me see, I'm confused. Inside the bag was a necklace. That was how it was asked in the bar, worth or valued 5 million. Now, he found by B, B did not report it to the custom police and instead pawned it with a pawn shop for 2 million. And it was accepted as collateral. Later on, the proceeds of the what do you call it? It's not chattel mortgage. The pledge, the proceeds of the pledge is deposited with a bank. Now, the bank reports B to the AMLA, and now B is prosecuted for anti-money laundering. The question, it's in the question. Only qualified theft is included among the enumeration of predicate crimes. Ordinary theft. Now, a theft is qualified if committed by servants, if there is breach of trust and confidence, or if the subject matter is a motor vehicle, or if the subject matter is cattle rustling, although is cattle, or if it is theft in the fish pond, or theft of coconuts. So that is the definition of qualified theft. Now, what was committed by B is simple theft. The question is B liable under the Money Laundering Act? Period. The answer given by my friend, Dean Nilo Divina of UST, is that B cannot be prosecuted for money laundering because the predicate crime he committed is simple theft, not qualified theft, because there is no abuse of confidence involved. And since economic activity enumerates includes in the enumeration only qualified theft, then B is not liable for money laundering. Now, that's correct, because criminal law, the question is, although asked in commercial law, the question is he liable? And remember the pro reo doctrine that criminal law is construed strictly against the state and in favor of the accused. But if I would be the examiner, this will be my question. What arguments can you raise to make me liable for qualified theft? To make be liable for anti-money laundering. What is the philosophy behind the law? To establish unlawful source of funds. And for that purpose, that should be reported. But I am not contesting the answer, because exclusio unius, exclusio alterius. Simple theft is not considered. But if you want to justify why he is guilty, then I will argue that the enumeration of economic activities are only by way of illustration and example. And any other economic activities where unlawful source of where funds sourced from unlawful activities are transacted should fall under the philosophy, spirit, purpose, and goal. No, you know, sometimes you are being tested to come up with a logical argument, not necessarily an argument that may eventually be sustained. So, here in my study guide for the bar, I ask a question, and I ask a problem. The facts are given, and then the question is not a simple one. There are always two sides to an issue. And for question number 1, I am asking for an answer to present arguments in favor of the plaintiff. Question number 2, argue for the side of the defendants. And question number 3, decide the case with reasons. So I have a sampler here because that was our training way back in the early 70s. I entered the UP College of Law in 1966. And so we have Professor Maria Clara Lopez Campos and the husband, Justice Jose Piping Campos, who became a member of the Supreme Court. When he was the examiner in commercial law, he gave a problem, single problem, with many issues involved. And then he asked questions to resolve specific questions based only on one single problem, long and winded, involving several issues. And if I'm not mistaken, he would prove the reasoning ability of the bar-takers by requiring them to argue on both sides. Because there is according to Charles Lamb, he is not a good lawyer who cannot take both sides, meaning that represent one side and represent another side, not in the same case, but in another case, in another separate cases. The reason is there is the general rule, there is the exception, and sometimes exception to the exception, and still further exception to the exception. And that is the beauty of the law. Now, when you are being considered by a client on a big case, do not tell the client that you will lose the case because he will go to another lawyer. So you present alternative theories, and it's up to him to adapt his theory of the case. After all, it is his case. And so sometimes when you present alternative defenses, sometimes the weaker of the defenses is the one sustained. When you present several theories that are not inconsistent with each other. I will have a story under the Anti-Graft and Corrupt Practices Act. On the case I handled for Miriam Defensor Santiago before the First Division of the Sandigan Bayan, on the legalization of 32 Chinese nationals involving the controversial question of continuing offense and the interplay of possible defenses under the revised criminal procedure. I will reserve that when we go to remedial law. Now, after this, don't worry about financial rehabilitation and insolvency act of year 210, because that is the line of my practice, and I taught that for many years in the Ateneo Graduate School, and that has been the practice. And I guess that our law firm in the Makati area is the one that started this practice on corporate suspension and rehabilitation. When I took my postgraduate studies in the University of Michigan, I specialized on corporate suspensions and rehabilitation. And I wrote my thesis, a comparative analysis of corporate suspension of payments and rehabilitation, Philippines and U.S. And that is the old bankruptcy law, the old insolvency law, compared to the Federal Bankruptcy Act of the United States at that time. And I recommended legislative reforms. And now we have corporate FRIA, Financial Rehabilitation and Insolvency Act. And my office is practicing that principally, probably because we specialized in that. So when I was conducting seminar against foreclosures, when the interest rate reached up to 57% in the Philippines, it was really because of the Asian currency crisis. I was Senior Vice President, Head of Legal of Commercial Bank of Manila. I resigned, and I handled borrowers. So when I was conducting seminar for never mind, I will not mention the name. After the seminar, many clients would line up in my law office because there were not many practitioners on extrajudicial foreclosures and corporate suspension of payments. And so I have made an outline, a comprehensive outline of corporate suspension of payments. Now, there is a question that was asked in the last bar examination. Here goes the problem. Mateo and members of his family is a stockholder of a corporation. Because of long litigation with a rival corporation, B, A suffered liquidity problem and filed a petition for corporate rehabilitation. Now, B, before any commencement order or stay order may be issued, which is supposed to be issued within 5 days from the filing of the petition, obtained a writ of execution on a case against the members of the Mateo family. The sheriff a law student, immediately garnished the bank account of Mateo and members of his family. The question is, it is stated that Mateo is contesting the writ of execution because a corporation is controlled by his family. Question: is the objection of Mateo sustainable? Number one, the issue calls for the separate juridical personality. Mateo and members of his family as stockholders of the corporation which has filed for suspension of payments may be garnished because only the petitioner for corporate suspension of payments, Corporation B, is entitled to stay order and suspension of all claims against the petitioner. The stockholders have separate juridical personality and are not covered by the stay order. Now, exception to the stay order, and this is what I want to discuss with you because this is embodied in decisions of the Supreme Court. How about, let us say that in that example, Mateo acted as a surety for the obligation of A, and there is already a judgment against A or against Mateo, against A under the JSS. Question: is that covered by the stay? The answer is no. The stay order does not benefit the surety. Now, question: with respect to real estate mortgage, is a real estate mortgage executed by a third party, let us say the stockholder, to secure the obligation of A, is the third-party corporate mortgagor entitled to the stay order of in favor of A? There is a distinction between a surety and a mortgage. A mortgage, if it is executed by the corporation, may be foreclosed subject to the clearance of the bankruptcy court if it is not necessary for successful rehabilitation. But if it is necessary for successful rehabilitation, for example, transportation company, and you are going to foreclose on the chattel mortgage on the buses, that the chattels are necessary for successful rehabilitation. And so what would be the remedy? Probably from other sources. There might be a switching of collateral or if payment may be made subject to the approval of the insolvency court. Now, how about a guarantor as distinguished from a surety? A guarantor is entitled to the stay because there is a benefit of excusation that the asset of the principal borrower who is under corporate rehabilitation must first be exhausted, and since it is under suspension of payments, then the stay order benefits a guarantor. So that is the distinction. Now, if it is a mortgage by a third party, which is a corporation, then you should correlate this with the principle in corporation law on ultra vires act and what I failed to discuss, the trust fund doctrine. I'll discuss it now. Related to ultra vires act is the trust fund doctrine. A corporation cannot execute a third-party mortgage to secure or answer for the obligation of another corporation. Why? Because it will violate the ultra vires doctrine and the trust fund doctrine. Now, under the trust fund doctrine, the assets of the corporation are reserved for the benefit of the creditors. Before anything during liquidation may be given as liquidating dividends, all the creditors must be paid. That is the trust fund doctrine. And relating that to ultra vires doctrine, a corporation cannot act as a guarantor or a surety to answer for the obligation of another because that is outside the principal function of an ordinary corporation. Only a bonding company or banks can issue letters of credit, but then that is outside the coverage. Now, what I am emphasizing is under the ultra vires doctrine, a corporation cannot be a guarantor. Now, let us correlate this to Section 66 of the Negotiable Instruments Law. Warranties of a general endorser. Under the Corporation Code, by express provision, because of the ultra vires act and the that the assets are reserved for the benefit of creditors. When a corporation becomes an endorser of a negotiable promissory note, the endorsement is valid, but the corporation is not liable as a general endorser. And what are the liabilities of a general endorser? If the check bounces because of forgery, because it has no funds, an endorser warrants the genuineness of the signature of prior parties under the warranty of a general endorser. And a general endorser warrants that if there is no sufficient fund in the bank, then the general endorser is liable to pay for as long as notice of dishonor is given. And he warrants the genuineness and due execution of all prior parties. However, by express provision of the Negotiable Instruments Law, the negotiation is valid, but the corporate endorser is not liable for the warranties of a person negotiating by endorsement. And what is the reason for that? Trust fund doctrine. Because if he will be liable for the warranties, that is to pay if the issuer is bankrupt, then that will violate the trust fund doctrine. And that will exceed his authority. But then, to facilitate trade and commerce, the negotiable instruments law considers the negotiation of by a corporation as valid, but it does not bind or make the corporation liable for warranties of a general endorser. The procedure in corporate suspension of payments, I have outlined this, where a single proprietorship is entitled, and what are the requisites. There are two definitions of insolvency. It would seem that insolvency on the equity sense, that the corporation has assets more than its liabilities, is a requirement. Because when you file for a petition for insolvency, you have to submit the appraisal, the financial report in the last 3 years. And it would seem under the implementing rules that solvency in the equity sense, meaning more than assets than liabilities, is necessary. However, there is another definition of insolvency, and that is failure to meet the obligations as they mature, and that is in the old insolvency law. So that with respect to banks, if a bank cannot meet the obligations as they mature, as for example, if it declares a bank holiday, meaning that it closed its door to depositors who are withdrawing banks from their deposits. This is a ground to place the bank on receivership. But where there are practices that are inimical to the public, there is a provision in the banking law that the BSP may close the bank before investigating the bank. But again, I am tempted to discuss with you the doctrine of primary jurisdiction and the doctrine of prejudicial question. But I will not do that now. We will do it in remedial law after civil law. What is the effect of issuing a commencement order? The commencement order sets the case for meeting with creditors, and the purpose of the meeting is to examine the rehabilitation plan which must already be included in the petition. You know, when we filed a petition for rehabilitation for a large corporation, there were 5 this high, because you have to include the inventory of all the assets. You have to include the titles, all the titles to the property inventory included in the inventory, and you have to attach the real estate mortgage, promissory note, and then you have to make an inventory listing the creditors and their respective addresses, and then their claims. And you have to show in the inventory that you are still in the black. If you will look at the implementing rules, it would seem that what is required is being in the black under the balance sheet test. Although there is in the equity test in the United States, there is another form of insolvency, and that is failure to meet the obligations of creditors as they mature. So that is a due to temporary liquidity, and that has been adopted by our legislator in the new Banking Act called BSP, Bangko Sentral ng Pilipinas. And one of the grounds for putting a bank under receivership is being insolvent in the equity sense. Having more assets than liabilities, it cannot meet its obligations as they mature. Now, question. May a petitioner who has less assets than liabilities file for suspension of payments, rehabilitation and suspension of payments? Under the law on rehabilitation, when the jurisdiction was still with the Securities and Exchange Commission, there is what is called extraordinary rehabilitation, where the assets are less than the liabilities, but there is a reasonable likelihood of successful rehabilitation. So a rehabilitation may still be applied for, but a management committee must be organized, and that is under the jurisprudence when the jurisdiction over corporate suspension of payments, insolvency, corporate rehabilitation were still under the jurisdiction of the SEC. It is now an unsettled matter. Under the financial rehabilitation, under the FRIA, where solvency in the equity sense seems to be a requirement because of the required submission of the financial statement and inventory of assets what is the purpose? Where, for example, a rehabilitation petition was filed in Zamboanga, but there are pending cases by or against the petitioner in other venues. The provision in the stay order absorbs all the existing claims by or against the petitioner. These are all absorbed, shall be suspended, and shall be brought to the rehabilitation court. Now, the rehabilitation court may allow other cases, pending cases to continue if under the doctrine of primary jurisdiction. For example, it is a labor case. Then it might be allowed to continue in the Department of Labor because the Department of Labor has primary jurisdiction. But the case should be reported to the bankruptcy court and clearance should be requested. The same thing with other cases. Now, exception, if there is already a decision and it is pending in the Supreme Court, that is not covered by the rules. The rule in extrajudicial foreclosure of real estate applicable to the insolvency law under the old insolvency law. The rule is that the mortgagee may snub the rehabilitation, the insolvency court, and just focus and be content with the extrajudicial foreclosure. But under the present Financial Rehabilitation and Insolvency Act, the extrajudicial foreclosure will have to be stayed and will have to be reported to the insolvency or rehabilitation court. Because even in straight insolvency, bankruptcy or insolvency liquidation, the mortgagor cannot foreclose for 6 months. It has to be discussed in the insolvency court. Now, there are many provisions that are controversial. For example, what is the cram down? That is the rehabilitation court in the process of rehabilitation may give a haircut to unsecured creditors. However, a secured creditors, like a holder of a mortgage, chattel mortgage, pledge, they are entitled to the benefit of, to the extent of the value of their collateral. And if their claims would be reduced under the cram down provision, it cannot be lesser than the value of the collateral. Now, what is the floor for unsecured creditors under the cram down? The entitlement under the rehabilitation plan to be paid to the secured creditors should not be lower than the amount that they will pay, that they will get if the company will be liquidated, similar to a fire sale, within 3 months. So anything, if they will get anything below that, that will be a violation of their constitutional right. So, how long is the period that might be allowed under the FRIA? Up to 15 years as may be necessary. And so, there may be a reduction, the so-called haircut. Now, what is the effect on executory contracts where a commencement order has been issued? Let us go back to civil law. An obligation to do cannot be compelled by a specific performance. It is only an obligation to give that may be compelled by a specific performance. So, let us say that Pacquiao filed for corporate suspension of payments and no, not proprietor, corporate, individual suspension of payments. There is a stay order, and he does not want to fight. What would be the remedy? He cannot be compelled to fight. So, he may be required to pay damages, but then payment of damages is subject to suspension of payments. A personal obligation to do cannot be compelled by specific performance. So, where there are executory contracts, then the petitioner may adopt, for example, a lease, or may break the lease and pay damages. And the damages is subject to suspension of payments. Now, I have outlined the different kinds of possible settlement under suspension of payments. So, I hope that I can make this available to you so that the areas in the coverage that I might not have tackled it's all here, I make it as comprehensive for future reference of those who will take the bar after 2022. But then, I made it a point to cover all the coverage and the integration, assimilation, and correlation with other principles. For example, in the last bar, a question was asked on independent director, which is required in public corporation. Now, a public corporation such as banks, insurance company, cannot be a closed corporation. The question asked last time was related to the definition of what is a public company other than those who are listed in the stock exchange. And so the problem given, the capital stock is 80 million. The stockholders were 300, and with 200 shares each, with so that falls under the definition of public tender offer, because a corporation with such capital ownership, stockholders with at least 200 with at least 100 shares, that falls under the definition of a public corporation. And a public corporation must have an independent director. So that is the correlation, because there is no definition of what is a public corporation that requires an independent director, meaning a director who, to be independent, he is not related to any officer or any stockholder in the corporation. That's why he is independent. And that is an exception to the requirement that a stockholder must own at least one share to be entitled to a seat in the board. So most of the tricky questions were requiring correlation with and integration with related principle. So in my practice, where a corporation is the guarantor or the third-party mortgagor, I always invoke ultra vires acts of this guarantee incorporation and the trust fund doctrines. And as an example is the negotiation by endorsement of a corporation. It is valid, but it does not render the corporate endorser liable for breach of warranties, such as solvency of the issuer of the check. I will make available before the pre-week, maybe 3 hours each, on how to answer bar questions, and I will share with you my analysis of previous bar questions. Those were simple in the sense that the answer calls for an application of your knowledge of the law, and I repeat my advice. Do not introduce facts that are not in the problem, and do not discuss any principles that are not called for by the question. Just limit to answering the question, and that will be indicated in the answers to bar that I have incorporated in my new study guide. Next Saturday, October 8, we will have a session in civil law, and I will start at 2 o'clock, and if necessary, may continue into the evening hours, because civil law is divided into 2, morning and afternoon, and so that will be requiring maybe longer discussions on my part. So thank you for your patience in listening to me. I will see you next Saturday, if not earlier. If I have something earlier, maybe in the middle of the week, we can also, something like this, in the late afternoon.